Good evening, everyone. Now that you're all awake. Welcome to this very special Chancellor's Lecture, Battle Supreme, Politics, the Law, and an Open Seat on the Nation's Highest Court. My name is Samia Ali, and I'm a third-year student at Vanderbilt Law School, and tonight I have the honor of introducing our distinguished guests, who will engage us in an important and timely roundtable discussion on the Supreme Court vacancy. First, I would like to introduce our host and Chancellor, Nicholas S. Zeppos. The Chancellor has served as Vanderbilt's 8th Chancellor since 2008 and guided the university as interim Chancellor in 2007. Prior to this, he served as Vanderbilt's Provost for almost 6 years, and he has taught and continues to teach classes at Vanderbilt. He is a distinguished legal scholar who served as an attorney for the United States Department of Justice, Appellate Staff Civil Division, in our nation's capital from 1982 to 87. Chancellor, will you please join us on stage?
82. When they said 1982,
Next, we have Judge Andrew P. Napolitano. He is the youngest life-tenured Superior Court judge in the history of the state of New Jersey. He taught constitutional law and jurisprudence at Delaware Law School and at Seton Hall, where he was voted by the students as their most outstanding professor. In 1995, he returned to private practice and began television work the same year. As Fox News senior judicial analyst, Judge broadcasts nationwide on the Fox News channel. He lectures nationally on the U.S. Constitution, the rule of law, civil liberties in wartime, and human freedom. His weekly newspaper column is read by millions every week. He is also the author of 7 books on the U.S. Constitution, 2 of which have been New York Times bestsellers. Please join me in welcoming special guest to the stage, Judge Andrew Napolitano. Our next speaker is Jeffrey Toobin, best-selling author of The Nine, Too Close to Call, A Vast Conspiracy, and The Run of His Life. Mr. Toobin is a staff writer at The New Yorker and senior legal analyst at CNN. He has covered all the major legal stories of the era, ranging from the nomination of 4 Supreme Court justices to the trials of Michael Jackson and George Zimmerman. Mr. Toobin has interviewed President Obama about his judicial selections and written articles on subjects such as Attorneys General Eric Holder and John Ashcroft. His most recent book, The Oath, The Obama White House and the Supreme Court, was a New York Times bestseller. Early in his career, he served as an assistant U.S. attorney in Brooklyn and as an associate counsel in the Office of Independent Counsel with Lawrence E. Walsh. Mr. Toobin, it's an honor to welcome you to Vanderbilt. Please join us on stage.
Thank you.
Thank you. Our next guest is Audrey J. Anderson, and she's the Vice Chancellor, General Counsel, and University Secretary for Vanderbilt University. Ms. Anderson served the Department of Homeland Security beginning in 2009 and was Deputy General Counsel from 2011 until she left in March of 2013. Her duties at the department included advising on significant litigation and legislative matters and working with the Transportation Security Administration and the Federal Emergency Management Agency. Ms. Anderson was also a partner in the education and litigation practice groups at the law firm of Hogan & Hartson, where her practice focused on representing and advising public school districts and managing healthcare companies and litigation and other matters. Ms. Anderson served as the adjunct member of the faculty of the American University Washington School of Law in 2006 and 2007. Vanderbilt is fortunate to have the expertise of Ms. Anderson guiding all of our legal matters, and we're pleased to have her as a part of this discussion tonight. Ms. Anderson, please join us on the stage. Our final guest is Jon Meacham. He's a Vanderbilt University Distinguished Visiting Professor and Pulitzer Prize-winning author. Professor is a residential historian, contributing editor at Time, and executive vice president and executive editor at Random House. His latest book is Destiny and Power, The American Odyssey of George Herbert Walker Bush. His other books include American Lion, Andrew Jackson in the White House, Thomas Jefferson, The Art of Power, and Franklin and Winston, An Intimate Portrait of an Epic Friendship, all of which have been New York Times bestsellers. Professor Meacham is a regular guest on Morning Joe and also occasionally appears on Meet the Press, Charlie Rose, and other broadcasts. He is editor-at-large of WNET Public Media, New York's public television station. Will you please join me in welcoming Professor Jon Meacham?
Clap louder, Chancellor.
I hope you all enjoy tonight's discussion. Thank you.
Thank you. Well, it's really a privilege to be here with such a distinguished panel, and I want to welcome everybody to this really exhilarating event where we are going to really call on the best minds, the most prominent pundits, to opine and eventually predict where this will all end up. And so with that, let me just start out with a question that I think is kind of hopefully an innocent one, and I'll start with Jon. Jon, are there lessons from history here? I mean, we are in a debate about this is what we're going to do. Is there anything that we can learn from history, and how would you apply that to this situation?
Well, the two things come to mind. One is this idea that you leave the court open in the last year of a term is ahistorical at best. There's little precedent for it. Taft, Wilson, FDR, Eisenhower did a recess appointment, President Reagan, all appointed in the last year of a term. So the idea that you should allow the voice of the people to be heard before you fill a vacancy forecloses the possibility that perhaps you heard the voice of the people last time and it's still carried, which is what we tend to do in a constitutional order. So that's one thing. The other is, it's a very mixed bag, as we know, like hiring for anything. You get some winners and you get some not so great appointees. My experience in writing about presidents is if they take a deep interest in it, they have a better average. My most recent subject, President Bush, spent very little time on his Supreme Court appointees. He regretted one very much, David Souter. He called it a huge mistake. But he only asked him 2 questions, neither of which were about anything involving the court. There's a picture of President Bush interviewing Justice Thomas, soon to be Justice Thomas, at Kennebunkport that you would think had been staged by Ralph Lauren. The president's wearing white tube socks and docksiders, sitting in kind of a Mark Hampton bedroom. And they had about a 6-minute conversation. And then they went off and had some crab meat and English muffins, and that was it. That was the interview. And Mrs. Bush had sort of blown it early on because when Judge Thomas at that point arrived, he'd been smuggled to Kennebunkport and brought in the back. And before his interview, Mrs. Bush saw him and said, "Congratulations." So that took the pressure off. So that's, those 2 appointments, I think, presidents who engage deeply in it, I think ultimately are happier, certainly, with their appointees.
I have found that presidents who are lawyers tend to take more of an interest in the intellect and thinking of the nominee than presidents who are not lawyers. It doesn't always follow, but it has followed in the modern era. In the past 2 weeks, I spent some time in audiences like this with Justice Sotomayor and with my Princeton classmate, Justice Alito. So Justice Alito was told, show up at this hotel on a Friday night and register under an assumed name, and we're going to give you the name, and walk out of the hotel and go to this street corner at 6 o'clock in the morning, and a black sedan will flash its high beams 3 times, get in the car, and just be yourself thereafter. 5 minutes after he gets into the car, he's in the White House living quarters with Barney the dog on his lap, having scrambled eggs with George Bush, talking about how a guy from New Jersey can root for the Phillies. This is George W. Bush, who asked him no,
The apple
according to
didn't
Justice.
fall far from the tree.
Right.
Yeah.
We asked him no substantive questions at all. Justice Sotomayor, on the other hand, said the toughest grilling she got in the entire process was by Barack Obama himself, who knew of her rulings on the district court and the circuit court and quoted some of them back to her. Now, they're simpatico ideologically and even intellectually, but she said it was a serious interrogation, and I didn't know if I had it. As far as I knew, there were 5 other people coming in there after me or had been in there before me.
Jeffrey, does arguing from history make a difference in this current climate?
Well, let me just to give my take on sort of what's the circumstances now. You know, there up until Justice Scalia's death, there were 6 Catholics and 3 Jews on the court. First time in history there were no Protestants. There were 6 men and 3 women. First time in history there are 3 women. There were representatives of 4 New York City boroughs on the Supreme Court. You had Ruth
That was in the Constitution.
Ruth Ginsburg from Queens, Antonin Scalia. I'm sorry, Ruth Ginsburg from Brooklyn, Antonin Scalia from
But
Queens.
wait a minute, Scalia was born in Trenton, New Jersey.
Yeah, but he grew up in Queens. And Sonia Sotomayor from the Bronx and Elena Kagan from Manhattan. Tragically, Staten Island has been unrepresented on the Supreme Court.
Wait a minute.
But
Commodore Vanderbilt was born on Staten Island.
there you go. Well, his many achievements did not include being. So anyway, those are background facts, which I submit to you are not terribly important. What's important are that there are 4 Democratic appointees on the Supreme Court and 4 Republican appointees on the Supreme Court. And the reason why the Republican Party is going to war over Merrick Garland is only because of that. Because we are looking at the first time in my conscious lifetime that the Supreme Court could have a liberal majority. Has not happened since the late Warren Court. And that's what this fight is about. It's not about who's a good justice, who's a bad justice. It's about the politics of the Supreme Court. And the stakes are enormous. And that's why there's a fight here.
Do you think that Scalia's visibility as the leading conservative intellectual has also moved the discourse in a certain way? Because, when, I don't know if it was Lewis Powell was the swing vote, if you're solidly in one camp or the other, it's like, as long as we get one of our own. Now you've got maybe a 5th vote, but does Scalia's visibility make it even more so?
Perhaps a little, but I think the Republicans in the Senate are very sophisticated about what's going on here. So if, God forbid, the vacancy had been Justice Thomas or Justice Alito or the Chief Justice, we'd be having the same fight because they can count votes like anyone else. Yeah. Yes, Justice Scalia was extremely visible and not as influential as many people think he was, but he was certainly important. But he was a conservative vote, and that's what it meant, that a conservative vote left to be replaced by an Obama appointee if this person were confirmed.
Yeah. Does it, Audrey, you spent a fair amount of time with the justices. Does it surprise you that justices have it's leaked out that if you're going to appoint a justice, appoint Elena Kagan, that the justices care less about that 5th vote than the public does? So does the court really just want someone appointed? Or are 4 conservatives cheering to get a solid vote back with Scalia? Do the justices care?
Well, I think you might get a different answer from 8 different people. I think it's always dangerous to say what the justices care about, but I would think that they mostly care about getting another colleague so that they can continue with their business.
Yeah.
I think it's hard to keep the business of the court going when there's only 8 people there.
Yeah.
I think that they are also looking at history, and I think that they are sophisticated and know that the kinds of arguments that are being made don't hold a lot of water. But they also understand the politics and know how much is at stake, so they can't be surprised at what's going on right now.
I by coincidence, was at dinner with Justice Scalia and another member of the court, I won't give you that person's name, the night that President Obama announced the nomination of Elena Kagan. She had been the dean of Harvard Law School at the time he announced her nomination. She was the Solicitor General, the government's chief lawyer before the Supreme Court. Justice Scalia was elated at her brilliance and her background. The other justice who was there was furious, saying, I've just lost my vote because she's going to vote the opposite way that I vote on everything. And that other justice, again, I don't want to give you the person's name, was closely allied to the ideological views of Justice Scalia. So you had two conservatives looking at Elena Kagan at the same time and in the same respect and coming to the opposite conclusion.
Let's go to the current process. Should they allow a vote? I mean, what are people nervous that a vote would carry because of swing state senators? Why not allow a vote?
Well, I have opined that, and I think Jeff probably agrees with me on this, that Judge Merrick Garland is the most conservative, traditionalist judicial nominee by a Democrat to the Supreme Court of the United States since FDR nominated his Attorney General Bob Jackson in 1941. And that in any time but this, the Republicans would and should welcome him with open arms. In some respects, he's more traditionalist than Justice Scalia on criminal law, Fourth Amendment issues, and on surveillance issues. I can say this with confidence because one of my jobs at Fox, as soon as he was nominated, was to review his decisions on hot-button areas. But of course, this is a different environment. Justice Scalia is dead. He was an icon to the conservatives, and the Republicans want to draw a line in the sand. Now, if you're asking me if they will cave, I mean, I don't know how to predict if they will cave. I think the president expects them to cave. Judge Garland is a good, decent, brilliant, hardworking guy. I can't even imagine he would let himself be used like this if he didn't think they would cave.
I agree with most of that, especially about how conservative Judge Garland is compared to other Democratic nominees. I think there is no chance the Republicans are going to cave. I mean, certainly not before November. I mean, there is some chance that if the Democrats retake the Senate and the Republicans are looking at a Hillary Clinton presidency with a Democratic Senate, they may say, let's just get Garland off the table, and instead of getting, a 45-year-old African-American lesbian in February. So I think that's I think that's the only possibility Merrick Garland will get confirmed under this Senate.
But he is so much more conservative than Elena Kagan and Sonia Sotomayor.
Sure,
it's almost hard to believe the same mind nominated all three of them, unless the nomination of Merrick Garland is for some other reason, like to pick off Republican senators running for re-election who find defending the non-vote distasteful and destructive to their re-election campaigns. And I can think of 6 of them.
Well, there's 6 of them who are in vulnerable seats.
Yes.
And this is a problem for them, but they've made their decision. I mean, they can't suddenly say, well, on second thought, we should give him a hearing.
That would never
and I'll
happen
vote
in
for him.
politics.
You know what? I actually think. I actually think one of the things journalists do too much of is, interpreting what people say instead of listening to what politicians say. When you hear Republican after Republican say, when Republican after Republican says, the next president should fill this seat, what I think they mean is the next president should fill this seat, and that precludes even a lame duck appointment.
I think when they say that, it's because they think it's the popular thing to say. Because why do they say anything? Because they want to get reelected. And if they are convinced that saying that will not help their reelection chances, they'll say something else.
Go ahead, John.
But remember who said it first. I remember talking to a senior member of the Republican Senate caucus after Senator McConnell had announced there'd be no vote. I don't think Scalia was out of Texas yet before he announced it.
You're absolutely right.
He was still there, yeah. And it's best to get out of Texas as quickly as possible in most cases. But
After all they've done for you on the last
it's
book.
so true.
Yeah.
That was very unkind, I know. But if it weren't for us, they'd still be part of Spain. So anyway, he said, this is Senator McConnell, and I said to the senator I was talking to, did he tell you all he was going to do this? Was there an email or something? And the senator said, why would he start now? So this is the man, remember, who 7 years ago said we're going to make Barack Obama a one-term president. So I think you have to look at the personalities on the Hill as well. Senator McConnell has made a decision 7 years ago, and we are living in as partisan an era, I'd argue, as the 1850s. And so I think Jeff's right. I don't think they're going to suddenly reverse themselves.
How does it play out in the presidential election? How does the spot play out at the high level, and then how does it play out in swing states if it matters? And then Senate races.
Well, it's been
What
such
are-
an
what are the
ordinary
presidents-
it's been
what
such
are
an
the
ordinary
candidates?
presidential year. There's a lot of analogies. I think we're through the looking glass on all of this. We're sitting here on the 2nd of May, and Donald Trump is arguably going to be the Republican nominee for president. I think at that point you suspend all analogy.
Yeah.
Right?
But you did say Alice in Wonderland.
Yeah.
But how does, if we have a Trump, Clinton, how does each use it?
Well, Trump argues, I will find another Antonin Scalia, and the crowd will roar.
Yeah.
And Hillary says, Merrick Garland is a great man, and if I am elected, I will re-nominate him, and her crowd will roar.
I don't know about that.
She does.
Okay.
I don't think she's going to say.
She's already said
She'll say. No, she hasn't said she'll renominate him. She said he's wonderful and they should vote for him. But I don't think she is going to commit, and she has not yet committed on whether she would renominate him. Because why doesn't she pick a 45-year-old instead? And a lot of her supporters agree with you that he is the most conservative Democratic appointee. So why should she appoint the most conservative Democratic?
She doesn't want to be seen as rebuffing the president. She's running for his third term.
No, I'm not saying, but for that's she's supporting his nominee, and so she does support Garland. But I at least, correct me if I'm wrong. I have not heard her say that she would renominate him, and I think it's a very open question of whether she would.
Here's what she said. If she's elected, she will not ask the president to withdraw his name.
During the lame duck, yes.
Correct. So
Right.
that from the time of her election,
Right.
which is early December at the Electoral College, and the time of her inauguration, the Republicans who would still control the Senate for the first 3/4 of that time could
Yes, they
confirm it.
But what if the president says, you know what? I finally convinced that Mitch McConnell is right. The next president
Yes.
should appoint. Really? I think there are so many on-ramps and off-ramps
Yes.
here.
Yes.
Where
the president has been saying all along, this is my nominee, this is my nominee. How can he say on November 5th, well, to heck with them? It's just not going to happen.
I don't think. I
know,
think.
you have
I think he appointed him because he thought this was my best shot to get a moderate through the Senate, and I think it's perfectly possible. I don't know, Audrey and John, what you think, to say, wait a minute, I gave you the moderate who's 63 years old. I'm going to appoint a 45-year-old progressive and add more diversity to the court that is lacking, and or I'm going to let President Clinton do that.
Yeah, I think that Obama definitely could withdraw the nomination, notwithstanding what he said, and I think Garland could withdraw. I think there's all sorts of things that could happen.
Yeah, and he
I don't think that we should assume that Hillary, if she gets elected, is going to go full steam ahead with Merrick Garland.
And to go to your initial question, the issue here, if this were if this were even a remotely ordinary year, where the Republican nominee was not selling steaks, let's just take that off the table for a second. Then you would have, then this would be a critical issue for swing voters, presumably. Voters who would be undecided. For the 6 voters in Ohio who are undecided, they might factor in that this is the court for a generation and all of that. It's so strange. It's clearly, to my mind, it's a base election coming up in the general election. So I don't know ultimately how the choice is going to be so stark. It's not as though this appointment makes it seem even more so.
I agree with John.
Okay, go ahead.
This go off. I agree with John, but I also want to throw this out there. Barack Obama right now is concerned with his legacy, and I think his legacy would be materially tarnished if he walked back on the nomination of Merrick Garland after all the things he said about why the sitting president should have his nominee voted on, and all the very credible, documented, decent aspects of Merrick Garland's background, that Barack Obama would tarnish, at least in the short run, his legacy if he did that and said, let Hillary appoint
His
him.
whole argument has been, I was elected for 4 years.
Right.
Not until January of this year, as the Republicans seem to think, and not until
I think
November, as
You don't think things
this
change after
hypothesis.
the election?
No.
Where he's really saying, you
It's
think he
just
really
out of
was
the
saying,
question.
I am the president until the very last day, and I have the right to appoint as a lame duck?
Not a chance in the world. But I could be wrong.
Listen, what do I know? You're a scholar. You're on TV
Well,
all the time. I can't even run the university.
To go to your political question about the signature.
When you said you couldn't run the university.
No, they got nervous. They got nervous. Maybe, go ahead.
I've been covering the court for a long time, and in forums like this, people often ask, why isn't the court a bigger issue in the election? Because it's so important. And the fact is, it never is. Yeah. It's just too abstract. Right. But the one place where it might make some difference in this term, in the 2016 election, are in the swing states. The Ron Johnson in Wisconsin, Kathy Ayotte in New Hampshire, Toomey in Pennsylvania, where the failure to hold a vote plays into the perception of a lot of people that the Senate doesn't do its job. And the Democrats' argument, that they should do their job and give Garland a hearing, it might resonate somewhat with some voters. But I really wouldn't overstate what a big political issue it will be.
It could drive, at some level, maybe turnout for the president.
In very select.
We should have Gear come up.
The court to the public, I think, is mysterious and esoteric. And even though Scalia was this grand figure who frequently spoke to gatherings like this and was extremely well known and arguably broke the mold about not speaking out in public about your views on the court, I don't see it as even a numerically measurable issue in the campaign.
I agree.
Do you think that the court is now the process of appointment and confirmation is more politicized, which has politicized the court? And so that its public respect will kind of go into decline, and people will see it as everybody is political, maybe all 3 branches, but how political you are might vary over time. So how much are we really hurting the court, and what would the Chief Justice say about this in private?
It's a 2-part question.
Yeah.
I think one you're asking about, has the process for confirmation tarnished the court?
Yeah.
And the other is you're asking if members of the court dig their heels in on political issues.
Well, I'm really saying, are we hurting the court's legitimacy because it's some removed from politics gives it some credibility?
I think that the image of the process was severely tarnished with the Robert Bork and Clarence Thomas confirmation issues. One rejected by 52 to 48, Bork, one confirmed by 52 to 48, Thomas, but only after the most acrimonious, almost shocking public events. Do I think that has harmed the court? No, not at all. Jeff and I cover the court. It is not always 5-4. It is not even frequently 5-4. It is not always liberals against conservatives. Many of the issues before the court, if there are law students here, they'll know that, are so into the weeds and below the radar, there is no liberal or conservative view of it. It's the construction of a rule. It's the construction of a precedent. It's an effort to find out what the original thinking was on a particular issue. It's not Nino and the boys versus Ruth and the girls.
Yeah, I mostly disagree with that, actually.
You're so generous in
No,
your
I really do.
confirmation,
I think it is and always has been a deeply political institution. And yes, it is true that on many, many cases, the court is unanimous or close to unanimous. But when we're talking about the issues that get public attention, when we're talking about abortion, when we're talking about same-sex marriage, affirmative action, the future of the Voting Rights Act, there is a difference between Democratic and Republican appointees. There always will be, and that's okay. You know, elections have consequences, and but to pretend that there is this sort of kernel of law that is independent of politics, I just don't buy it for the most part about the issues that I'm discussing.
You have Republicans voting with Democrats like John Roberts on the Affordable Care Act. You have Anthony Kennedy and had Sandra Day O'Connor, Ronald Reagan nominees being swing votes to the point where you couldn't tell which way they were going to go. So it doesn't always follow that Republicans are united and Democrats are united.
Almost always.
Well, obviously a lot of cases when you look at the voting patterns where, you get an ERISA case or something like that. It's kind of like, all right, who cares?
View of that,
yeah,
right?
that's just a question of who gets the bad assignment of the opinion. So, but do you think we've magnified, Jeffrey, 8 cases a term or 5 cases a term and just magnified the politics? Isn't the judge right that there are a lot of cases, even in the criminal law with Scalia, where he was a strict constructionist of the Fourth Amendment, and much different from Audrey's chief on Fourth Amendment and right to jury trials, grand jury, confrontation clause.
Absolutely not. Absolutely not. We are talking about what matters to the people of the country, to the larger discussion about law in America, and it's about abortion, it's about gay rights, it's about affirmative action, and those are the cases that affect the most number of people. And with all respect to ERISA, it doesn't matter how those cases come out, except to the parties. The political cases are what these justices define their own legacies by. And I'm not saying that as criticism. I think, does the Constitution protect a woman's right to abortion? May a university consider race in admissions? I don't think those answers have legal answers. They are political questions as much as they are legal questions. And which president appoints the justice is going to determine in great measure how those cases come out. That's not criticism, but I think that's just a fact.
I think that the case that in our lifetimes made the public see the court really as politicized and how it reaches decisions is Bush v. Gore. Yes. Bush v. Gore is the case where the public finally understood what Jeff is talking about. That there aren't, for some cases, it's really hard to separate the law from your political or policy or values viewpoint in your head. I think Bush v. Gore is the one where people said, oh my gosh, the justices are practicing politics? If lawyers knew that for these cases that Jeff's talking about, but I think the public didn't.
It's an extreme example. It's a terrible case. It's meaningless constitutionally and for precedential value. It was just the Republicans deciding we're going to get Bush in there and end this stuff in Florida. On that, we agree. It was decided with intellectual dishonesty and politics foremost.
But I think
that is a very narrow class of cases.
Yeah, but-
Wait a second.
but no,
I thought you were at Fox, not MSNBC. What's up with that?
Do you see these fingerprints? It's from getting them burned all the time.
But I do, as you know, I do have to say that those cases you're talking about, Jeff, are not purely politics. There is law behind them, and having briefed those kinds of cases to the court and practiced in those areas of law before the court, there is law that you bring to bear. There are things that I think lawyers can intellectually disagree about and argue on one way or the other. It's wicked difficult to convince the justices. You're going up there saying, well, gosh, I've only got Kennedy to argue to in any event. But there are intellectual arguments you can make in all of those areas you're talking about. And it's not, even though, gay rights have, become politically popular, the lawyers still had to find legal hooks to hang their hats on and to find a way to get the justices, even the girls, to agree with them in an intellectually honest way.
Exactly, and to some extent, that's why it's a headline when John Roberts votes for Obamacare.
Exactly.
Yes.
That's what we're noting, right? So,
Yes.
and you're right. I mean, Bush v. Gore is sort of the Pearl Harbor of modern court partisanship, right?
Yes,
I mean,
yes.
It's just, and you don't have to go back to Jefferson trying to impeach judges, or John Marshall's now made his decision, now let him enforce it. You only have to go back 16 years. And I think that is the most vivid example, and it's
And yet,
but remember, as Bill Clinton will tell you at length, which is redundant, presidents are only remembered for 2 or 3 things, and Supreme Court, how many precedents actually sort of enter even the sophisticated political consciousness? Not many.
but for all my conservative buddies that railed against the John Roberts decision in the Affordable Care Act, I have reminded them that the principle that the Congress can tax anything it wants and spend the money any way it wants is something they like in other areas. It is a well-grounded intellectual academic principle. They may not like the way it was used today, but he didn't make it up, and he won't be the last person to rely on it. Right. And it was the coalescing a view that got the 4 liberals and the Chief Justice to uphold the Affordable Care Act.
Rachel Maddow and you have become Rachel Maddow. It's unbelievable. This is fantastic.
We do have some differences.
What about, are we done with using judicial restraint as the kind of test? I'm struck by most of the federal laws that are struck down or narrowly interpreted at the court are by a conservative wing. You look at the Voting Rights Act, you look at votes on the Affordable Care Act coming up twice. What are we to make of the concept of judicial restraint, given the political nature of things, which is activist on both sides?
Judge Harvey Wilkinson, who's a conservative Republican on the Fourth Circuit, has a great book out in which he argues that in return for lifetime tenure, I had lifetime tenure. Obviously, I don't have it now because I'm in television. In return...
That's the opposite.
That is not lifetime tenure.
Right, that's for sure. In return for lifetime tenure, judges should be modest and restrained. I know of no other member of the federal judiciary who joins in making that argument. The lifetime tenures have the opposite effect. There are some federal judges here. It has unleashed them to do the right thing in their own minds, irrespective of constraints, irrespective of politics, irrespective of the outcome.
There was a wonderful sort of paired series of cases in recent years. The Voting Rights Act case passed overwhelmingly by the House and Senate, signed by that notorious radical George W. Bush, and Justice Scalia, in the oral argument of that case, said, honest to God, he said, well, isn't the fact that it passed overwhelmingly proof that it's just political? And the Democrats were arguing, on the court, the more liberal, were saying, we should honor Congress's intent. And the conservatives voted against them 5-4 and said, no, we want to overrule the Voting Rights Act. The next year, the court took up the Defense of Marriage Act, which was passed overwhelmingly by the House and Senate and signed by that notorious reactionary Bill Clinton. And the Republicans were saying, well, we have to defer to Congress. And the Democrats were saying, oh, we can't defer to Congress. This is a discriminatory law. Again, it was a perfect reversal of positions. Both laws passed overwhelmingly, both overturned by 5-4 margins, with the justices' politics, I think, being the determining factor in each vote.
I think one way of perhaps, so you all might disagree with this, to frame what you both have just said, is there is this institutionalization of hypocrisy.
That's wonderful, John.
Right? I mean, because
That's wonderful.
it's judicial activism if you disagree.
Right,
It's overreaching if you don't like it.
right, right.
But it's the wisdom of the ages reaching forward to right or wrong if you agree with it. And we wonder why the system has given us a real estate developer. It's...
Well, I was with you almost until the end.
I
don't know how you get to a real estate developer out of that. Yeah.
But the whole...
And don't be so insulting. There are real estate developers.
I love real estate
in
developers.
The audience.
No, I'm
We'll
very
take
for
great
it.
offense on that.
I'm for it. I'm for it. If the development office is here,
Well, I mean-
I apologize.
I think the person you're describing is beyond real estate development.
Very
I
much
thought
so.
all he did was license the use of his name.
That's right. That's true. That's true. But there is something about this in the broad political imagination of the country right now. Part of the frustration is that when people hear debates, when they hear assertions and enunciations of principle, they know that there's a level of hypocrisy that's prevailing in
I
many
agree
ways.
with John. It brings us back to where you started, if I may. The Republicans in the Senate, and the Democrats have been the same way when the situation was reversed, lack the moral courage to say, we will vote against Merrick Garland because we think he's too liberal for the court. They do not have the courage to do that, so they avoid having to do that by refusing to take the vote. They never acknowledge, there are some at the fringes who do that. Barack Obama voted against Sam Alito. Sam Alito was Princeton undergrad and Yale Law School and had been a stellar appellate judge. There was no question about his qualifications. Barack Obama didn't want that mindset on the court and was intellectually honest enough to say that when he was in the Senate.
Roberts, too.
Yes, he voted against Roberts, too, for the same reason.
Right.
Most senators lack that intellectual honesty, hidden behind the hypocrisy of, it's not his turn, it's not his time, Barack Obama shouldn't be making the nomination. But what they're really saying is, we don't like this guy because he's different than Anton and Scalia, but we can't say that because that doesn't wash well with the voters.
What, do you think that the people we're choosing to be justices are totally different from what we saw in prior generations?
I think there is been a very sad development on that front. The court that decided Brown v. Board of Education in 1954, not one of the judges had ever been a full-time judge before. Earl Warren was governor of California, Robert Jackson was the attorney general, Hugo Black was a senator, Felix Frankfurter was a law professor, William O. Douglas was head of the SEC. They had big, broad experience in the world, in part because of the Bork hearings, I think, and the fact that Bork had expressed views on many critical issues and was penalized for that. There has been this series of appointees who are very narrow people. When Alito replaced O'Connor, all 9 justices were former federal appeals court judges. I think the court really misses something when they don't have former elected officials. Justice O'Connor, who was a state senator, brought a lot to the court by that alone. And I think it's a real shame that the breadth of experience is much narrower than it used to be.
The last Supreme Court justice to be nominated with no judicial experience is probably someone very few people in this room have heard of, even though he served during the lifetime of all of us, and that's Lewis Powell, who was a lawyer in Virginia and the head of the American Bar Association, and Richard Nixon liked him.
Right. Well,
And he
Elena
was
Kagan, too. I mean, Elena Kagan was not a judge.
Let me ask you, the other thing is, if they practiced law, they were in OLC, the SG's office. Is there anyone that practiced in the private sector?
Who's now on the court?
After John,
A little bit.
who?
Yeah.
Well, Kagan was at a law firm for a little while.
Well, but that's
Scalia-
like doing the 2
Scalia
years.
was a law. Was
No,
a
no,
law-
but I'm saying like
Well,
John Paul
Sonia,
Stevens.
Sonia Sotomayor was a
No,
state
but
prosecutor.
actually worked in private practice over periods of time to
Sure.
manage
Sure.
large cases and large clients,
Only
or
the last one was Powell.
Well, no,
John Paul
Roberts.
Stevens.
Roberts
You're
was there
not.
for a long
We're not
time.
buying what you're selling here. Kagan, Sotomayor, Roberts. They all had some
they-
private sector experience.
it was like 2 or 3 years, very little.
It's not 2 or 3 years.
I just don't think
You
that,
know-
I think that missing, what is it like to represent people
Right.
over long periods of your career as a lawyer?
All right, here's one
and
you'll-
understand the implications
one
of
you'll-
law, other than, I was in the Solicitor General's office, or I was in OLC, or I did 3 years at Audrey's firm and then went to become a professor.
Here's one you'll both agree with. There is nobody on the court who ever defended somebody accused of a crime. There's nobody on the court who ever did criminal defense work. There's nobody on the court who ever argued in court that the Fourth Amendment violations by the police ought to let my client off, even though he did it.
I think that is a real gap.
Yes.
I completely agree that is a real
Jeff, do you
gap.
think it's exacerbated?
Wait, John Roberts assisted on criminal cases for defendants and appeals when
Pro
he was
bono?
at when he was at Hogan and
bono,
Hart.
he did some
When he was at Hogan and
He did
Hartson.
practice for a fair period of time. Do you also worry that they have a narrow background and they're so young? So it's not like the court is maybe the area where you see the fullness of life. It's a pretty cloistered, so does that bother you as well?
One of the things that I love about the Supreme Court, it's the last place in America where 50 is young. I don't think they're so young. Look, we can talk about their backgrounds and all this. You know what matters? Their ideology.
Yes.
If they're Democrats or Republicans, that's what matters. And yes, some of them did a few years in this job, or some of them did a few years in that job. I think John, is exactly right that this is a deeply ideological moment in our history, and far more important than any particular aspect of their background is their ideology, because Democrats and Republicans see things differently these days.
So, Jeff, you might be right for those small number of cases that everybody's worried about, but I think that when you're talking about the large part of the cases that are the court's bread and butter, that the people who bring the cases to the court really care about, where they're having to solve real problems of real people in the United States and make real law that is going to matter, even if is really going to matter to people, even if they don't really know about it or care about it. I think the backgrounds of the lawyers who are bringing to the court is very important, way beyond their ideology, because it really matters if they understand how those things work. I mean,
you are exactly right. I care about those small handful of cases a lot more than I care about those other cases. They'll take care of themselves.
I think those cases affect a lot of people, though. You get a labor case.
Yeah,
or-
everyone who's affected by an ERISA case, raise your hand.
Yeah, but I mean,
everybody
fail-
is.
Almost
everyone is.
everybody will be
Everybody
affected by
is.
ERISA if they have a pension.
Everybody is.
Incredibly
There's a guy who
narrow
says-
questions that they deal with in ERISA. How many people have
Fair
a
labor
gay
standard.
relative or are gay people? That's a big group.
No.
I mean, come
Who
on.
has
All
an
right, all right.
employment? Who has a
All right.
retirement? Who has
I
a
think-
retirement account?
Retirement.
Okay, you're
What if it's-
affected by
what if it's not
ERISA.
big enough?
Yeah.
I mean,
All right. Okay. Well, this is very interesting.
This is the most conversation about ERISA.
I don't think it's just ERISA. I think there are a lot of other cases.
yeah, a lot of
The
them.
ERISA,
Banking,
the ERISA
banking cases.
No, the ERISA primary is
Financial
on May 10th.
regulation. I can't wait for you to come complain about your retirement plan. Okay, we have some excellent questions here. This must be for, how many vacancies do you foresee in the next several years? And if this goes on with every justice, does it get easier once the 5-4 is broken?
You know, Justice Scalia told me many times his greatest fear was that he'd be replaced by a president who profoundly disagreed with him. And that, I think I can say this now that he's no longer with us, if a Republican is elected in 2016, he'd be gone on January 21st, 2017. But if a Republican is elected in 2016, he'd stay on as long as he could. So if Hillary Clinton is elected president, Ruth Bader Ginsburg and Stephen Breyer may start to look at another pasture. But if a Republican is elected president, I don't think they're going to go voluntarily for the reasons that you articulated.
I completely agree. And Chief Justice Rehnquist was very explicit about this when he was on the court. He said there is a tradition of leaving when the president of your party is in power. And also, it's just human nature. I mean, you know, Justice Scalia recognized that if a Democrat replaced him and the court, you know, changed to a Democratic majority, his life's work could be undone. Who would want that?
Right.
I mean, I don't begrudge the justices. I mean, this is one of the reasons why I think life tenure is a bad idea, because it encourages these people to hang on for too long. But since life tenure is the system that we have, you are going to have justices hang on until they have a congenial president. That's what happened with Stevens and
Now,
Sawyer.
there is an anomaly to that argument, and that is Ruth Bader Ginsburg, who was pressured very, very aggressively by the left to leave now while Barack Obama is president, so that she, at age 84, could be replaced with a like-minded age 44. And she basically told them where they could go.
She certainly did, and there are a lot of people who continue to resent her for that, much as they love the notorious RBG.
Yes.
There are people who think that she was acting selfishly considering what she believes in. Now, if Hillary Clinton's president, it effectively won't matter, but you're absolutely right. There were a lot of people who thought she should have
To
left.
leave voluntarily, but nature does take its course, as
Well,
we've
why
learned.
shouldn't people live
And so,
voluntarily?
well, I'm
I
not,
mean, you know,
I'm
there's
just
a
saying,
reason why 84-year-olds don't hold many jobs in America.
so,
Because they're too old. I mean, respectfully, but I mean, you know.
you were trashing the 50-year-olds before. Okay.
Believe me,
So,
no, I'm
so
not.
we spent a lot of time talking about the Supreme Court and maybe in some people's eyes a focus on a small group of cases. What do you make of the politics of appointment and confirmation of circuit and district court vacancies and the political process? Because that's where a large part of the judicial work, even in these political cases, are done.
You know, I have the great joy, and you may have this joy as a former law professor, of having a former student of mine nominated to the United States District Court to become a federal judge. And he and I do not see eye to eye on a lot of issues, but I love him. I know his intellect. I taught him constitutional law. I taught him criminal procedure. He's a brilliant state judge. But because he was nominated by Barack Obama, he's a Democrat, this young man. And because the Republicans control the Senate and are doing what they're doing with Merrick Garland, he might not become a district court judge, and he should. Ordinarily, at that level, it's not a policy-making court. It's you get nominated, you don't vomit on your shoes during your hearing before the Judiciary Committee, you get confirmed. There's a little bit of politics in the circuit court, but none of it at the district court, which is the trial court level.
I think that's right, although I also think that, you know, that too has become more political. And remember, you know, during the last period when the Democrats were in the majority, there were so many filibusters against these lower court nominees that Harry Reid engineered the so-called nuclear option, which means that filibusters are no longer valid or no longer part of the Senate rules for district and circuit court judges. And if, by the way, the Democrats retake the Senate and President Hillary Clinton's nominees are stymied indefinitely for the Supreme Court, don't think that Majority Leader Chuck Schumer will not invoke the nuclear option for Supreme Court vacancies as well. And by the way, I think the world would be better off without filibusters, period. But that's, that's a separate issue, sort of.
What is the role of the court in looking at the democratic or undemocratic nature of the party conventions? And is there any role for the court in that process? Because many people see it as undemocratic, and I get that they're private organizations, but
You go to a vote in a primary, you use the same voting equipment as you do in a general election, you go to the same place, people wear the same buttons, they try and persuade you to do the same thing. It looks like an election, it smells like an election, it feels like an election. It's not an election. It's a decision by a private organization. All the courts have said this. The Republican Party is a private organization. If they want to enact rules that let Ted Cruz do this to the Trump delegates, they can do it. The Democratic Party is a private organization. If they want to enact rules that give Hillary Clinton this many superdelegates, even though Bernie won this percentage of the primary, the courts are not going to get involved. I mean, if the parties were to say 2 + 2 = 22, you might get a judge that would interfere with that. But beyond something that egregious, I don't think there's a role for the courts in telling the parties how to manage their own organizations.
I think that's absolutely right. But it is worth pausing to reflect on just how undemocratic some of these rules are. I mean, the classic examples being the Democrats have all these superdelegates who, are not elected or answerable to anyone, and both parties have caucuses, which are outrageous. I mean, the Iowa caucuses, it's a significant part of the presidential election in our country that in the middle of January, people have to go stand around for 2.5 hours at night on a weeknight. I mean, who can possibly do that? I mean, what about people who work? What about people with small kids at home? What about people who work at night? I mean, it is fiendishly undemocratic, but I think His Honor is clearly correct that the courts were not going to get involved with that.
Back to the hypocrisy for a second. This is the selection of party candidates today is vastly more democratic and has been for the last 30 years or so than it ever was early on in American history.
Right.
We do sort of pretend
Yes.
that it's even more so, but Dwight Eisenhower was convinced to run for president because he came in second in New Hampshire. This was a great, in 1952. So
Hubert Humphrey in 1968 didn't even run in the primaries.
right. Yeah. This is all. It's within the last 40 years or so.
last question, would you change the way Supreme Court justices serve or nominated and confirmed and serve? You get rid of life tenure. What proposal would you advocate to fix this, or just we're going through a phase?
There's an excellent proposal by a group of law professors, which I heartily support, which basically says each president would get 2 appointments, and they would have 18-year terms, and it's a great idea, and it'll never happen in a million years. One of the good things about our Constitution is that it's very difficult to amend, because God knows what we would have done to it if it were easy to amend. This is an area where I think an amendment would be a good idea, but it's not going to happen. And in the realm of issues in America, lifetime appointment for the Supreme Court, to me, I mean, if I were designing things from scratch, I'd do it differently, but I don't think it's a horrendous problem.
I think that it's a good thing that we have lifetime tenure. It's sometimes a good thing that a president can serve without appointing anybody to the Supreme Court. The whole purpose of an independent judiciary is to be anti-democratic, not to reflect the will of the people, but to preserve our institutions, to preserve our liberties, to preserve the rights of the minority against a majority, and I wouldn't want a popular majority to be able to change that.
Well said.
I agree.
Audrey, you agree with that?
I do.
Can I ask the judge a question?
Hypocrisy.
All right, you'll have
Which
to.
I am for, by the way.
No, in one's personal life, it's a great thing.
Last question.
You know your New York neighbor, Mr. Trump.
I do.
So let's talk about attorney general candidates and what kind of folks, if this happens, if he were to become the 45th president of the United States, what would he do in terms of appointees?
Well, I have to, in full disclosure, have a financial relationship with him. We own a piece of real estate together, and he manages it, and he does a great job. And the Donald Trump I know is very, very, very different from the person we see at these huge rallies. But knowing him, I would think he would not want a Janet Reno type who would appoint an independent prosecutor or designate someone to investigate him. He'd want someone subservient to him in virtually every respect. But I honestly don't think he has given a great deal of thought. Fill in the blank after that. to the nature of the Attorney General in his administration.
Right. But
Now I'm going to get in trouble again.
This is unbelievable what I'm hearing here.
But justices, have you ever had a conversation with him about does he have a favorite Supreme Court justice?
He has praised Justice Scalia to the skies. I have never discussed this with him.
You'd probably start with those TV judges. All right. Let's give a loud round of applause for this phenomenal panel here.
Thank you. You're
Thank you.
sweet.
Oh, no.
It's fun.
Jeff, I tell you, I'm just... Hey, Charlie.